check your account on the 2nd, the rent's not there. You check again on the 5th, still nothing. No message, no explanation, just silence. This is the most stressful situation in property management. And it's also where landlords make their most expensive mistakes. Because how you handle the next few days matters a lot. I'm Michael with Darling Property Management, and today we're walking through exactly what happens legally when your tenant stops paying rent in Texas. What the law requires, what you're allowed to do, and what mistakes will slow you down when you can't afford to wait. And this applies whether you're managing your first rental or if you've got properties spread across Dallas and Collin County. The process is the same, and if you follow it, it'll protect you. Before you do anything, let's talk about timing, because there's a specific window between when rent is due and when you can actually charge for being late. Under the Texas Property Code, you cannot charge a late fee until the rent has been unpaid for 2 full days after the due date. So if rent is due on the 1st, and for most Texas leases it is, you can't charge a late fee until the 4th. That's the law. How much can you charge? The law says late fees have to be reasonable. Texas defines that as 12% of monthly rent for properties with 4 units or fewer, the standard for most single-family rentals here in DFW. On a $2,000 a month lease, that's $240. But it has to be spelled out in your lease before you can collect it. One more thing, you cannot pass utility company late charges to your tenant. Senate Bill 603, which took effect in September of 2025, specifically prohibits that. So, wait out the grace period, then the late fee kicks in on day 3, but you're still waiting at this point. Here's where things get serious and where I need you to pay close attention, because Texas law changed this year on January 1st, 2026, and most DFW landlords don't know it yet. Under the Texas Property Code, you have to give your tenant written notice to vacate before you can file an eviction. The default is 3 days. If your lease doesn't spell out a different period, it's 3 days. But here's what Senate Bill 38 added. If this is the first time your tenant has ever missed a payment, their very first late rent, the notice you serve has to say pay rent or vacate, not just vacate. And they now have 72 hours to catch up before you can move forward. That distinction matters. First offense gets a chance to cure. If they've been late before, you can skip that language and serve the standard 3-day notice to vacate. But how do you deliver it? Texas gives you a few options. Mail it, hand deliver it to any tenant 16 years or older, leave it in a conspicuous place inside the unit, or under the new SB 38, you can send it by email if you and your tenant both agreed to that in writing when they signed the lease. As always, keep a copy of everything and document how you delivered it. If the tenant disputes the notice in court, your paper trail is what will protect you. Once the notice period expires and the tenant still hasn't paid or moved out, you file a forcible detainer suit in the Justice of the Peace Court in the precinct where your property is located. Texas has some of the lowest eviction filing fees in the country, typically around $46 to $55. After you file, the court clerk issues a citation to the tenant. Under SB 38's updated rules, that citation has to be served within 5 business days. The hearing then gets set no sooner than 10 days and no later than 20 days after you file. And here's something most people don't realize. JP Court moves fast. The judge typically rules the same day. This is not a months-long legal battle in most cases. What to bring? Your lease, the notice you served with delivery of proof, your rent payment record showing the missed payment, and any written communications between you and the tenant. Organized and clean. Judges see a lot of these cases. The landlords who are prepared move through quickly. So make sure your documents are in chronological order, organized, and easy for the judge to read. At the hearing, both sides present their case. For a straightforward non-payment situation with clean paperwork, the judge typically rules the same day. If you win, the tenant has 5 calendar days to file an appeal in county court. Under SB 38, tenants who appeal now have to swear, under threat of perjury, that the appeal is in good faith and not just a delay tactic. That's a real change because delaying through the appeals process was a go-to move before January 2026. If there is an appeal, the tenant usually has to post a bond equal to 1 month's rent, and they may need to pay ongoing rent into the court registry while the appeal plays out. Once you've won and the appeal window closes, or if there's no appeal, you request a writ of possession. The constable posts it, and the tenant has 24 hours from that posting before it's executed. From the day you serve the first notice to actual lockout, 21 to 40 days typically. Faster than most states, but only if every step was done right. All right, so let's talk about what separates landlords who move through this process cleanly from the ones who end up starting over. Mistake number 1, accepting partial payment after you've served a notice. This trips up a lot of landlords. If you accept any rent after filing for eviction, you may have waived your right to continue the case. Acceptance of rent can reset the clock. If you're in the process and the tenant offers you money, don't take it without talking to an attorney first. Mistake number 2 is trying to force the tenant out yourself. The Texas Property Code makes self-help evictions illegal. No changing the locks, no removing doors or windows, no shutting off utilities. Landlords who go this route expose themselves to serious liability, and judges don't look kindly on it. Mistake number 3, and there's no excuses for this one, is no documentation. Your payment records, your written communications, your notice with delivery proof, your lease, all of it matters if anything gets disrupted. Keep records from day 1. And mistake 4, waiting too long. DFW landlords who sit on a missed payment for 2 or 3 weeks before serving the notice, that's $2,000 or more in lost rent before they even filed. The process works, it just has to start on time. To close, I think it's important to note nobody wants to go through an eviction. The best protection is putting the right tenant in your property in the first place. That's what our screening process is designed to do. But if you're already dealing with a situation like this, or you're a DFW landlord who'd rather have a team handling this for you, we'd love to help. Click the link in the description for a free rental analysis. No obligation, no pressure. We'll look at your property and tell you exactly how we'd manage it. If this was helpful, hit subscribe. We put out new content every week for North Texas rental property owners. And if you're dealing with something right now, drop it in the comments. We read every single one and we'd love to help. Thanks for watching. We'll see you next time.